I am Megan Powell, and this is my colleague, Michael O'Neill. We both work for a title insurance company, First American Title Insurance Company. We also both participate in the American Land Title Association Native American Lands Work Group. I'm the chair of that work group, and Michael is a very active member, I'll say. We are really grateful to be here today to talk with you all about the Nonintercourse Act and some of the challenges that we feel like this act presents for the title industry and insuring transactions, and for tribes that are working on development of their fee lands. So before we get into those details, though, Michael is going to kick us off with just a little bit of history of the Nonintercourse Act, and then we'll move into the insurance quandaries. So I'm going to go ahead and pass this over.
Well, good afternoon, and thank you, everybody. Megan invited me to come talk to all of you today. I said, well, how much time do we have to talk about the Nonintercourse Act? She said, we have 90 minutes. And I thought, oh my gosh, how are we going to talk about a statute which is 48 words long for 90 minutes? And so there's actually not a lot of doctrine on certain aspects of it. Some is really detailed doctrine. We'll get into some of that. But as I think about the Nonintercourse Act, Section 177, it's as much about history as it is about applicability today in legal doctrine. And so I thought, well, let's use some of our time to talk about the history of it, where it comes from, what its purposes are, because I think that all informs what it means for us today. So to start us off, like I said, we'll talk about a few topics. One will be the historical foundations of Section 177, how that has evolved over time, and then, as Megan said, we'll get into some sort of modern practical challenges and responses to those challenges. So I'll begin by talking about the big historical arc of the Nonintercourse Act in Section 177. What is it? Where does it come from? It's a statute that's on the books, has been on the books since the founding of America. I'll offer a couple of theses or observations about it at the outset. The first is that it looks like it's just a law about real estate conveyances. On its face, that's what it's about. And yet, nonetheless, I believe it's one of the fundamental laws that have ever been enacted in our history. It's sometimes described as being a relic or as being antiquated, but actually, I don't think it's some dusty piece of ancient history for us. I think it's something that's very much alive today. The second observation I'll make is that the text has been almost static, relatively static for the past 233 years. And yet, it has applied throughout American history, throughout a very interesting, evolving, tumultuous landscape, from the treaty-making era through assimilation and allotment eras, through the termination era, through the modern era of tribal sovereignty, through those eras of federal Indian policy. There have been lots of concepts that have come to the fore. The concept of, for example, of a reservation. What is that? What are trust lands? These things come into being over time after the enactment of the Nonintercourse Act. And yet this static text has remained in place across all of these changing legal landscapes. The final observation I'll make before we jump in is really flows from the first two that I made, and that is that despite being nearly as old as the Constitution itself, despite being that old, the statute is actually surprisingly unclear as to its modern application. There's been quite surprisingly little litigation on what it actually means, especially outside of the context of Aboriginal land claims. So we'll talk about some of this history, about how it came to be, what were the antecedents and backgrounds to the Nonintercourse Act, and how it was applied over time. And you see some of that historical arc up on the screen today. So into the historical foundations. First place to start is looking at the colonial era charters that were granted by the English kings to the English settlers along the East Coast, and the interactions of those settlers with the native inhabitants of America. I think it's correct to say that there's probably no single theory behind the issuance of charters to the settler colonies, but many of them used phrases such as They would grant the property, the lands in absolute property. Pennsylvania's, for example, said they granted lands in true and absolute proprietaries. The theory under the Stuart kings of England seemed to be that the king could actually grant land, yet the practice was surprisingly different. Roger Williams is one of the great examples of an early settler, the founder of Providence Plantation, modern Rhode Island, who engaged in land purchases, entered into contracts and purchased land from native inhabitants. And when he received his grant in 1643 and 1663 later, these grants expressly referred to those purchases and confirmed them. In other words, the practice on the ground was not, in fact, that the king had granted the land, but that the land was to be purchased. This brings us to sort of what fundamentally the act stood for when it was first enacted, and that is the doctrine of preemption. And we'll talk about preemption quite a bit throughout this talk as it comes up in several contexts. Preemption is, in the famous case of Johnson v. McIntosh, one of the foundational doctrines of federal Indian policy. But as it was formulated by Justice Marshall in his decision, in practice, it was actually not as uniform as he suggested in his opinion. Preemption was part of what back then was called the jus gentium, that is the general law of nations or law of people. Today we would refer to that as a doctrine of international law. The actual practice of international law by the European powers when they were settling in the New World varied tremendously. The Spanish views are set forth primarily in papal bulls that were issued. The famous bull of Inter Cetera, which divided the New World, or purported to, between Spain and Portugal, did not mention native land rights. The later papal bull issued under Paul III in 1537, Sublimus Deus, did say that Indians should enjoy the legitimate possessions of their properties. French views and practice differed. In fact, the French king under Francis I rejected the notion that Inter Cetera even applied to North America. And the French, when they were in Louisiana territories and in what's now Canada, actually engaged in very few actual grants or purchases of land because they were focused mainly on trade rather than settlement. We also have Dutch and Swedish practices and views in the New World, which took place in the 1620s and 1630s. For example, the famous Dutch legal historian Hugo Grotius agreed with the earlier Spanish theorist, very famous Francisco de Vitorio, who said that the native land rights should always be respected and must be purchased legitimately. We know classic examples of the Dutch purchasing Manhattan Island famously for goods that have been valued by modern historians at some $24. The Swedish purchases in the New World took place as well, Fort Christina, which is now modern Wilmington, Delaware. Nonetheless, Johnson v. McIntosh and Justice Marshall's decision essentially ignored this varied practice that we saw over the course of the 17th and 18th centuries by European powers. He formulates it as being sort of a single consistent practice. His view is something that should actually be contrasted with the view of Thomas Jefferson, who as Secretary of State in the 1790s was asked what his view of the doctrine of preemption was. And he responded that he believed that the doctrine of preemption actually only meant that the United States should have the sole and exclusive right of purchasing native lands, but that it actually implied no right of soil against the native possessors. In 1793, Jefferson went even further and said that the doctrine of preemption does not amount to any dominion whatsoever. It simply means that other nations of Europe were prevented from taking possession of lands. In other words, the doctrine was primarily directed against other European countries, other European powers, and did not define rights to land as between Native Americans and the English and later Americans. The actual genetic predecessor of the Nonintercourse Act isn't to be found, I believe, in any of these practices or theories, but actually colonial era ordinances, the actual practices on the ground. Over the course of the 17th and 18th century, the various colonies enacted ordinances, and they were a lot of variety in how they were actually structured, but I think they basically settled on some basic trends and themes. And What's interesting in this is that the colonies themselves seem to have claimed a right of preemption. That is, the right to purchase lands from Native Americans, the sole and exclusive right to do so. Not the British Crown, the colonies. And the goals were to reduce conflict and also, in many cases, simply to preserve land for the proprietors, the colonial proprietors who claimed land. I think this is the real statutory background. As an example, I show you the history and progression of the laws in the colony of Virginia. As you see on the screen, the earliest enactment in 1652 talks about the forbidding of selling lands, but actually the verbiage soon changes thereafter and talks about the purchases of lands being prohibited, again, without the consent of the assent of the assembly, that is the colonial assembly. This doctrine was embodied in Virginia law all the way up to the American Revolution and became part of the Constitution. I think this, for example, is what we should be looking at when we're understanding the background to the Non-Intercourse Act. British imperial views, of course, were not well articulated or stated for many years, but during the 7 Years' War, or what in North America is known as the French and Indian War, things came to a head. There was growing disorder along the frontier, and in 1753, so this is under King George II, the Board of Trade directed the New York colonial governor that purchases of lands from Native Americans ought to be only in His Majesty's name and at the public charge. In other words, the Crown was asserting a right of preemption, the sole and exclusive right to purchase lands in the 1750s. The purpose of these policies, both at the colonial level and by the British Crown, seemed to be multi-purpose. One was simply to, reduce conflict, as I mentioned, but another important component of this was simply to try to keep Native Americans on the sides of the British and later the colonial powers and not on the sides of the French. And again, this seems to have been a complete failure during the French and Indian War. The most famous proclamation, which you see in many of the history books, was issued by George III after the conclusion of the French and Indian War in the broader 7 Years' War. And that royal proclamation established two fundamental policies that have been with us ever since. The first policy, for the first time, established a concept which would later become known as Indian country, and that is an exclusive territory which was to be reserved to native inhabitants of the New World. The second doctrine embodied in this 1763 proclamation, of course, is the idea of preemption, which I've talked about. And so this brings us up to the American Revolution, when these doctrines became, as we saw, incorporated both into colonial and then later the early states and their statutes and their early constitutions under the Articles of Confederation, and then up into the adoption of the U.S. Constitution. I put together this slide. It's kind of unformatted, got kind of a little wonky here on the screen for the dates up at the top. I've never seen anyone actually chart this out, so this was my attempt to try to chart who's actually claiming and enforcing a doctrine of preemption over time during the American Revolution. And as you can see, it was claimed by both the Crown, by the colonies, by the 13 independent states at one point, and then ultimately the United States. There's some interesting variability on the doctrine of preemption as it applied outside of the boundaries of the original 13 colonies, for example, or whether the federal government under the new U.S. Constitution had concurrent rights of preemption or actually a superseding right against the original states. But these are mainly academic debates, because what happened is 1 year after the adoption of the Constitution, in 1790, the very first Congress enacted the very first Trade and Intercourse Act and established this doctrine of preemption as a matter of federal statutory law. Before we get into the evolution of the Trade and Intercourse Act, I've already mentioned the case of Johnson v. McIntosh, which is seen as one of the foundational cases to this evolving doctrine. But of course, as a practical matter, the holding in Johnson v. McIntosh did not depend upon the application of the Non-Intercourse Act. The reason is because the land cessions that were involved in that case predated the Constitution and indeed predated the creation of the United States and the Declaration of Independence. And so instead of relying upon the Non-Intercourse Act, you will search in vain in Justice Marshall's opinion for some rationale behind it. Was it those Virginia colonial ordinances that I pointed to and showed on the screen earlier? No, that doesn't seem to be the case. Was it Virginia's C2C charter? No, that's just a pointer in that direction. Was it the 1763 Royal Proclamation? If you read the opinion, Marshall says that it's an additional factor to consider. But in fact, what he hangs his hat on is this idea that there is simply universal recognition of this doctrine of preemption. As I said earlier, in other words, it was a matter of international law, and that means it applies as a matter of federal common law, at least as to Aboriginal titles, even after the adoption of the Constitution. But again, it was not the Non-Intercourse Act itself that was at play in this particular case because of the timing. The Non-Intercourse Act is part of a larger enactment or series of enactments which were generally known as the Trade and Intercourse Laws or Trade and Intercourse Acts. The original purpose of these acts seems to have been to implement the treaties that the federal government was negotiating with the tribes, implement them in the sense of enforcing the treaties against American citizens. As, for example, the early treaties with the Cherokee, 1791, I believe, did not contain any enforcement mechanisms, and that was seen as a deficiency in the treaties. And so these acts, the Trade and Intercourse Laws, were in many ways a supplement, a federal law supplement to the treaty-making process. The Trade and Intercourse Laws during the early Congresses were adopted as simply temporary measures. I think what you see here with this series of enactments is that Congress was kind of trying to grope eventually to some sort of settled policy. And so they intentionally put timeframes on them. The first one would expire after 2 years, and so it kept getting reenacted, kicking it out another 2, 3, 6 years before it was finally made permanent in 1802. Despite the fact that the Non-Intercourse Act has been enacted multiple times, in its current form it was enacted in 1874, or recodified at least. It's really the 1834 Act, which is the controlling text. Despite that, I will point out that federal courts have basically held that this is one continuous law over time. In other words, a cause of action under the Non-Intercourse Act, which happens in between one of these enactments, does not abate as a matter of law with the expiration of one and the reenactment of another. The Supreme Court has said that this should be construed as simply one continuous evolving but continuously in place act. And so thus a violation at any point in time can be enforced under the current codification of it. During these early decades, there were a lot of uncertainty as to the scope and meaning of this. But I would like to point out that it's part of a larger policy that was being established over time. And that 1834 enactment that I mentioned was the one that really is on the books today and is probably the most well-developed in terms of establishing under federal law a comprehensive set of policies. The author that has written about this most is Father Prucha in his numerous books, but one of his key early works, which I think was published all the way back in the 1960s, American Indian Policy in the Formative Years, gives a wonderful overview of the evolution of these policies. I think that it's important from a modern standpoint to understand the consequences of this evolving enactments over time, and I think we can point to several of them. First is that Congress was using its commerce power, its power under the Commerce Clause, to enact the Trade and Intercourse Laws. But in the Non-Intercourse Act, it directed the acquisition of lands to be used through the treaty power. In other words, engaging in land acquisitions by the federal government was to be through the constitutional treaty power, not through the Commerce Clause alone. This leads to another outcome and conclusion, and that is to a history of treating tribes as sovereign entities. In other words, what we might today call corporate or collective entities that possess inherent sovereignty and thus should be the object of the federal treaty power. And I think that has extremely important implications that continue, of course, till today. Another consequence of using the Non-Intercourse Act and using the federal treaty power is that negotiations and acquisitions and cessions of land all went through, as a matter of title, the federal government for large parts of America. And that means that for many tracts of land in the U.S., that the federal government, that means the United States, is the root of title after a federal patent was issued. And that has obvious continual relevance for us. And the last observation I'll make about the evolution of these laws over time is that the doctrine was originally one that was applied to Aboriginal titles, and it was one that was really a codification of the doctrine of preemption, and its purpose shifts over these early decades of American history. The earliest purpose was, of course, to keep the French out, or later to keep the Spanish out. After the early years of the Republic, the doctrine seems to be applied consistently by the federal government in order to keep settlers out of the western frontier, in order to constrain states and control the expansion of the United States. In other words, it becomes a tool for American domestic policy, not so much international affairs, after the early decades of the country. As a result of that, I think it's important to characterize the purpose of the act as one that's primarily, the primary purpose was to protect Indian title, protect tribal titles, no matter what their characterization is, Aboriginal, or whether they were as a result of the issuance of patents or part of treaty negotiations. In other words, the doctrine was to protect the tribal land base no matter how that was constituted. So we'll take a look briefly at the actual text of these acts as they evolved over time. This is kind of an interesting little exercise to see how they evolved over time. But this is the very first enactment in 1790, and this is essentially the text that we live with today, but with some minor changes. The first enactment in 1790 said that no sale of lands made by any Indians or any nation or tribe of Indians within the United States shall be valid to any person or persons, or to any state either, persons or states, that's important. That is, whether having the right of preemption to such lands or not, unless the same shall be made and duly executed at some public treaty held under the authority of the United States. As I mentioned earlier, this is a statute enacted under the commerce power, which directs the acquisition of lands to take place under the treaty power. It also leaves open, is ambiguous as to whether it believes that persons or states might have a concurrent right of preemption, and it says expressly that it applies whether or not they have such a right of preemption. You'll also notice in this early enactment it applies to individuals, it applies to Indians, and also to tribes. That changes over time. So in the second enactment of the Non-Intercourse Act in 1793, you see just a few minor changes. Sale becomes purchase or grant. In other words, the conduct that it prohibits changes. It also makes clear that unvalid or invalid title means neither valid in law or equity. But most importantly, it for the first time establishes a criminal offense, makes it a misdemeanor to not comply with the act. This was part of the strengthening of the trade and intercourse laws over time that I mentioned earlier, as Congress was using these acts primarily to enforce the treaties they were negotiating with tribes. The only minor change that happened in 1796 is purchase or grant now becomes purchase, grant, lease, or other conveyance. Otherwise, it's enacted in exactly the same form. It just is clarifying that purchase or grant also means not simply fee purchases, but also leaseholds and other types of conveyances of interests of land. 1799, no substantive changes whatsoever. 1802, the only change was that the act was made permanent. And then finally, in 1834, this is the act that we live with today, essentially. It deletes, as I said earlier, a reference to any Indians, so it no longer applies to individuals. It only applies to tribal lands. And thus, the recodification that we have today, these 48 words, with minor modifications, have remained on the books since 1790, essentially. No purchase, grant, or lease, or other conveyance of lands shall be of any validity in law or equity. So we're going to talk briefly about the evolving legacy and the importance of the Non-Intercourse Act in American history. One of the important cases about this and understanding its application has to do with Pueblo lands and the story of that over the course of from the mid-19th century to the early 20th century. We saw Pablo Padilla's, if you were in this room during the last session, gave a really wonderful presentation where he talked about some of this history. But the Pueblo story shows the importance and the power of the Non-Intercourse Act, and in this case, when it was held not to apply to tribal lands. This, after the 1848 Treaty of Guadalupe Hidalgo with Mexico, a few years after that, Congress expressly extended the Non-Intercourse Act by statute to all of the New Mexico and Utah territories. And yet, despite that, in 1869, the New Mexico Territorial Supreme Court held that it did not apply to Pueblo lands. The basis of that holding was, they pointed out to the fact that there were no treaties between the Pueblos and the federal government, although, as we heard from Pablo's presentation, there were treaties negotiated, simply none that were ratified by the Senate. And also that the federal government had not sent Indian agents, which they shortly did after the decision was made. Nonetheless, the U.S. Supreme Court held that the Non-Intercourse Act didn't apply in 1877 in the case of United States v. Joseph. The consequences of these decisions over these ensuing decades was that a large amount of land actually wound up passing out of native land ownership through sales, but also through other actions such as foreclosures or adverse possession delinquent taxes, for example. It was only in the New Mexico's Enabling Act in 1910 when Congress finally said that Pueblo lands are in fact Indian country and that Pueblo lands should be protected by the Non-Intercourse Act. This, of course, created a cloud on title for all these thousands of acres that had been acquired by American settlers over that time period. And it led to the United States Attorney General instituting a bunch of ejectment actions against these settlers. This led to the enactment in 1924 of the Pueblo Lands Act that applies to Pueblo lands today. So this is, I think, very salient. It's many cases a unique legal trajectory, a sui generis in American history, but the vital importance that the application or non-application of the Non-Intercourse Act would have on Native peoples. A more recent example is one that we're probably all more familiar with, and that is various eastern land claims that have been made under the Act for Aboriginal title. I won't go into a bunch of detail, because these are for vivid examples with probably very familiar to many or all of us. The ongoing litigation with the Oneida Nation is probably the primary example of the application in a modern context of the Non-Intercourse Act. Back in the teens or early 20s, there was the case of United States v. Boylan, where Julia Boylan was held a mortgage on some of the Oneida Nation lands and foreclosed on it. It was the very last 32 acres of tribal lands that the Oneida Nation held. And to my knowledge, this was the first time that the federal government actually stepped up and defended tribal lands by initiating a suit to enforce under the Non-Intercourse Act. And this was successfully held. The Second Circuit upheld the decision, which prevented the foreclosure of Mrs. Boylan's mortgage. Nonetheless, for the next 50 years or so, the official United States position was that tribes actually could not sue in federal court under Section 177 because of a lack of subject matter jurisdiction. That, of course, came to an end with the Supreme Court's decision in 1974 of the first Oneida case, Oneida 1, often referred to, which said that tribes themselves may sue under the Non-Intercourse Act to protect tribal lands. So this is just an example of the continuing relevance of this in American history. So now that I've given a historical overview, let's talk about the text of the Act in some more detail and its modern relevance today. As I said, there's lots of ambiguities. It's a very short text of only 48 words, and yet surprising amount of uncertainty in these words. First, let's break it up into its moving parts. There's a prohibition. This is the operative section. It prohibits the purchase, grant, lease, or conveyance. That's the conduct prohibited. And it prohibits that of lands or of any title or claim to lands. very broad term, from any Indian nation or tribe of Indians. In other words, tribal lands are prohibited from being purchased. There's an exception to this built into the Act, as we've mentioned several times earlier. It's that could be done by treaty or convention entered into by the Constitution. That's the only exception in Section 177 itself. And it provides a remedy. The remedy is that an attempt to purchase those lands has no validity in law or equity. There's also now that the penalty, $1,000 penalty, which we saw enacted in the early 1800s, is still part of the Act. So we have a federal consent requirement. We have to look at who are the sellers that are affected by this. What is it that to be an Indian tribe? What are the effects of violating it? And then what are Indian lands? What are the tribal lands that are actually within the scope, which is really the core of the modern issue with construing 177. The federal consent requirement is fairly easy to dispose of. And of course, the text says that it must be by treaty or convention. And one may ask, well, how can you possibly do that in the post-treaty era? Treaty making has ended after 1871, after all. Well, as a matter of legal doctrine, this is accomplished through subsequent statutory enactment. This is not a subsequent enactment that actually satisfies the condition in Section 177, but rather it operates either through a superordination provision, saying that the later law applies notwithstanding any other contrary provision. So that's a rule of construction which says that the later enactment takes precedence. Or it can also take effect by operation of the doctrine of implied repeal by a subsequent enactment. And a ton of statutes actually operate this way. The General Allotment Act very famously did so. It did not mention the Nonintercourse Act, and yet authorizes allotment. Various Rights of Way Act do so as well. I'll mention, for example, the Indian Financing Act of 1974, which specifically says that title to lands acquired through loans provided under that act shall be taken without any restriction on alienation. So lots of subsequent statutes that have been enacted, dozens and dozens of them, which actually work to supersede and satisfy this federal authority requirement. The next question is, what does it mean to be a tribe, an Indian tribe, or an Indian nation or tribe of Indians under Section 177? The answer is not that it means federally recognized tribe, but it actually means a tribe as defined in the case of Montoya v. United States. This is actually a very interesting outcome, but one of the outcomes of this is that it means that you do not need to be a federally recognized tribe in order to assert claims under the Non-Intercourse Act, at least as to Aboriginal lands. Of course, it's far easier, of course, for a federally recognized tribe to qualify as a tribe under the Non-Intercourse Act for all sorts of obvious reasons. But in fact, non-federally recognized tribes can and have frequently used it. In fact, in some cases have even used this act as a means to obtain federal recognition by getting the United States to enforce the act on the tribe's behalf. Kind of interesting wrinkle. Let's quickly look at the effects before we get into the real thorny question about what does it mean to mean Indian lands. The effects of the act are that first of all, that it's very strongly protective of the tribal land base. It applies on its face to both voluntary and involuntary conveyances. I think you'll see some scattered dicta in some cases that suggest that it doesn't apply to involuntary conveyances, but the vast majority of authorities' cases say that it does apply to both voluntary and involuntary conveyances. And of course, as a federal law, it preempts all state law on the subject. Now, it preempts all state law except where there is an overriding subsequent federal statutory authority, of which there are quite a few. And so this has created somewhat a Swiss cheese doctrine with respect to the act. For example, without some other federal overriding statutory authority, lands that are subject to Section 177 are not subject to state claims of eminent domain or adverse possession or involuntary liens. On its face, it would also prevent the foreclosure for non-payment of taxes, although there are a series of tax cases that say that subsequent federal legislation under the Allotment Acts did in fact lead to the taxability of land. And finally, it's important to point out that there's no general statute of limitations that applies to claims under the Non-Intercourse Act, But of course, there could be federal statutes of limitations against claims made against the United States, and the city of Sherrill, infamous city of Sherrill case, which provides for a new doctrinally ambiguous and somewhat confusing laches defense for delay in bringing suit. But nonetheless, the Non-Intercourse Act itself is not subject to a statute of limitations. Okay, this is the slide, and the next two slides are going to get into the meat of the conundrum and the ambiguity, and that is, what does it mean to be tribal lands? That's the fundamental question about Section 177. The text, of course, says that it applies to lands or of any title or claim to lands. We know that this means lands in any state. There was some ambiguity or some dispute during the early years of the Republic whether it applied in the original 13 states. Well, that has been decided conclusively in the Oneida I case in 1974. It obviously applies to Aboriginal title. Interestingly, it also applies to tribal trust lands. Now, this seems like somewhat of an odd result because putting land into trust, the United States holding fee simple title in trust, of course, prevents the land from being alienated and protects the tribal land base. So as a practical matter, it probably doesn't make much difference to say that Section 177 applies to tribal trust lands, except to the extent perhaps that Section 177 does give tribes an independent and an independent cause of action to protect the tribal land base themselves. In other words, they don't have to get the federal government to enforce their trust responsibility. But nonetheless, for example, in Cohen's handbook, the authors say that they believe that it clearly applies, that's their word, clearly applies to tribal trust lands. It also applies, as I said earlier, it applies not simply to recognized tribal lands, but also could apply to lands of non-federally recognized tribes. And there's a number of ways that those lands could actually be held. State reservations or state trust lands potentially could be subject to the Non-Intercourse Act if the tribes whose lands are in question could demonstrate that they are in fact a tribe under the Act, satisfying the Montoya test. The thorniest question, of course, is to whether this actually applies to tribal fee lands. Obviously, there's a huge number of categories of land that are fee lands. It overlaps with Aboriginal title in some cases. Pueblo lands, for example, are construed as being in fee simple since time immemorial, or either through grants from the Spanish Crown. There are some federal patents and treaties with tribes that grant tribes land in fee. Today, we often refer to these types of lands as restricted fee lands. Obviously, Section 177 applies to that. But what about purchases of land? Fee purchases of land, whether that's on reservation or off reservation purposes. I think that's the big question of which there's the largest divide in authority. This has never been decided, in fact, by the United States Supreme Court. And I cannot, of course, sit here and offer an answer or really even an opinion as to whether I believe that it applies to fee purchases. But I can point out the widely divergent views and conflicting views on this question. And of course, I could say that it's never been definitively decided. I'll also say that I think that the views that we see in some scholars and practitioners, even some lower court decisions and dicta, who express the view that the Non-Intercourse Act was intended to apply to Aboriginal lands, I think that's historically incorrect. And the history of the enactment and reenactment of the Act over time, applying it to tribal lands regardless of the form of title, even before the definitive enactment of the present statute in 1834, shows that that's very likely to be an incorrect view. So there's some evidence from lower court cases and other sources that suggest that it applies to all fee simple lands of tribes, period, nationwide, no matter where acquired. First of all, we can simply point to the broad statutory language. It says lands, or any interest in lands. No limitation inherent in that. We also have some congressional findings, some recent statutes that suggest that Congress, at least currently, believes that it applies to fee simple lands no matter where located. One of the more interesting opinions was an 1854 opinion by then Attorney General Jeremiah Black. The question was presented to him to get his opinion on the so-called Christian Indians, those are the Christian Munsee tribe, who acquired land from the United States that had been acquired previously from the Delaware tribe. In the Attorney General's opinion back then, he said that he cannot think that it applies merely to those Indian tribes who hold their lands by the original Indian title. In other words, Section 177 does not simply apply to Aboriginal title. Rather, he says, the words are broad enough to include a tribe holding lands by patent from the United States, and the purpose of the statute manifestly requires it to receive that construction. A similar Attorney General opinion from 1885, which I've put up on the screen, doesn't get into such specificity, but uses similarly broad language to say that the statutory provision is very comprehensive and general, and its operation does not depend upon the nature or the extent of title in question. There are, of course, a whole host of lower court pronouncements that are equally broad. I will point out, though, that in none of these cases does it seem that this pronouncement was actually crucial to the decision. In other words, it wasn't part of a holding in any of these cases. But nonetheless, a number of lower courts have pronounced in various terms and in various phrases that Section 177, in fact, applies to all tribal lands. Then there are, of course, opposing views. The arguments against this are varied and numerous. Some point to the history, which I've talked about earlier, saying that it should apply only to Aboriginal lands, which I believe is not historically accurate. The most famous case deciding or holding that the Nonintercourse Act at least does not apply to off-reservation fee lands is the Lummi Indian Tribe v. Whatcom County case in the Ninth Circuit in 1993. In that case, the Ninth Circuit held that once the restraint on alienation was removed from land and passed to a third-party purchaser, it no longer applied for all time. So that when a tribe comes and later reacquires title to land, Section 177 does not apply. A rather conflicting opinion was offered by the Solicitor of the Interior Department in 2009 in an opinion that I think caused a lot of people to scratch their heads in some way. In that opinion, the solicitor says that the better view of the law is that when tribes purchase new lands off reservation, and those lands are held by the tribe in fee, then those lands are not without more subject to Section 177. In other words, the solicitor suggests that there should be a distinction made between acquisitions of fee simple lands within Indian country, or in his phrase, inside a reservation, or outside. And only when the lands are acquired or inside a reservation does Section 177 apply by its own force. You'll see in the second quote he says that it does not extend to off-reservation lands held by a tribe in fee unless some extenuating circumstances exist. What those extenuating circumstances are not well defined. And I'll note that the authors of Cohen's most recent version of Cohen's federal handbook point out that this opinion added confusion to the debate over the applicability of Section 177, and also that it creates a distinction that appears to have no support in the actual case law on the topic. I'm going to skip through this slide, except only value of pointing this slide out is to say that Section 177 is not the sole restraint on alienation that exists under federal law. There are many statutes that impose restraints on alienation that protect tribal lands in one way or another. The Nonintercourse Act is simply what I would call maybe the grandfather of all of these, the original enactment. So let's, before I turn it over to Megan, talk briefly about the arguments for and against not whether it does or doesn't apply to various categories of land, but whether it should, the desirability of the restraint at all. I'm just distilling here. I've done quite a bit of reading, different points of view, talking to folks about this, and I'm trying to distill themes that I see in those conversations and what I see out there when I've read varying views on this. The first view, we'll go through quickly, why should it apply to lands and what are the benefits of it? And I think, of course, as we talked about, it's very strongly protective of tribal land base, and so therefore Section 177 serves as an important ally to preserve tribal lands. Of course, The history of the loss of tribal lands is the exact opposite of the first point, which is that a strong ally to protect tribal lands is necessary. A third important point is that Section 177, the Non-Intercourse Act, serves to reinforce the doctrine of tribal sovereignty and sovereign immunity. Sovereign immunity is often an important doctrine which can protect the application of state law and private claimants against tribes in court. And of course, Section 177 is an additional shield that serves that view. And throw up there a quote that comes from Cohen's Handbook, but I think is accurate, and that is that the dominant view today seems to be to continue to favor the restraint in order to preserve the land and in order to preserve distinct values. There are, of course, a lot of arguments against this that I've seen. Some years ago, there was a lively academic debate about whether the Non-Intercourse Act promoted economic efficiency or equal treatment. Interestingly, though, I found a thread of argument running through some of the discourse by advocates that actually the Non-Intercourse Act impinges on tribal sovereignty. In other words, it prevents tribes from exercising self-determination in many ways by preventing and erecting a barrier to the tribes' decisions on what to do with their lands. There's, of course, a discourse that is associated with this that runs throughout our history about the necessity of it. And of course, there is simply a history, which I'll show on the next slide, that shows that many tribes have in fact desired to remove the restraints on alienation, and specifically Section 177, from their lands in certain circumstances. And I threw up several quotes from some of these sources, which I think are characteristic of the views against. Senator Jeff Merkley's view is one that I think is worth pointing out and dwelling on for a second. He thinks that it's absurd that tribes were forced to get congressional approval before they could develop property that they privately own. Those are the views of his constituents, which he is here echoing in public. Senator Merkley said that tribes in Oregon should have the authority to sell, to set their own economic course. And an essential piece of that decision-making must be the flexibility to develop their own privately owned property. So I pull from Senator Merkley's comments a couple of themes that I've put in the column there, such as it actually winds up impinging on tribal sovereignty, not just supporting it. It also limits and prohibits prosperity and economic development, so that's number 5 on my list. I also, because Senator Merkley was the sponsor of specific legislation to remove the restraint on alienation from tribal land, obviously he believes that number 6 is the case as well, that some tribes simply desire to remove it for business transactions. And so, as we've seen over the last few years, last several decades, there have been a host of enactments. Congress keeps coming back time and again in order to remove the restraint on alienation from specific lands at the request of specific tribes. This is a cumbersome process because it takes getting an act of Congress. There's significant variability into how this is actually carried out, and the statutes that have been enacted specifically state that it does not apply to trust lands. And this is an example of one such piece of legislation among many. The Miami Tribe of Oklahoma, a very simple act that says, notwithstanding any other provision of law, there's that superordinating language which overrides the effect of other restraints on alienation, that the tribe may sell, lease, convey, or transfer any part of its real property that's not held in trust by the United States. Now we're going to talk about the practical problems of the Non-Intercourse Act and these debates about its applicability in the context of obtaining title insurance for real estate transactions. And for that, I'm going to pass it over to my colleague, Megan.
So we want to talk about, how that is impactful to tribes when they come to companies like ours and need to get an insurance policy for example, a lender. I'm going to give some examples later. But say they've gone to a lender, they want to get a loan, a construction loan, to develop land on their property that they've purchased in fee, and the question of the applicability of the Non-Intercourse Act comes up. Before I get there, I'm just going to break down the title insurance policy a little bit. Michael and I work for a title insurance company, which is different than hazard insurance. Like hazard insurance would be if there's, a fire and the improvement burns down, or, something like that. We issue policies that ensure the ownership of the title to the property and identify any liens and encumbrances and anything else in the public record that impacts the title to that property. If you are, selling property or mortgaging or leasing property, the entity or individual that is the beneficiary of that, so, the purchaser, the lender, the lessee, they are going to want insurance that, the person who is giving them a deed or giving them a mortgage actually is the owner of that property and has the right to do that, and that the title to that property is not encumbered by any kind of lien or agreement or, something else that would prevent them from wanting to purchase, lease, or lend on that property. So I just want to talk about the fundamentals of the title insurance policy a little bit to help explain, when the Non-Intercourse Act creates an issue in insurance. So the first thing I'll say is that, the main policies that we issue are an owner's policy and a loan policy. There are different variations, like there's a policy called a homeowner's policy that's frequently issued on residential property. But, at its core, we're typically issuing policies to owners or lenders. If somebody is leasing property, they would get an owner's policy with an endorsement to the policy that describes and defines, their interest as a lessee and how the policy form applies to them. So really what that policy is it's a contract. It's a contract between the title insurer, so for us it'd be First American, and then whoever's the named insured on that policy. So the policy identifies the insured, and it's got a jacket, a policy jacket. And in that jacket, it specifies what are the risks that we are covering under this policy. So if you look at the jacket, it'll have a certain number of risks. And you can see here when I've got the arrow pointing to covered risks, it talks about, subject to the terms of the policy, these are the risks that we're giving you coverage for. And then there'll be a list, which isn't included in that screen cap. It's also, subject to the conditions of the policy outlined in the jacket. So just like any contract, there's going to be terms and conditions of the contract between the parties that are entering into that contract. It's also subject to the exclusions from coverage in the policy that are outlined in the policy jacket. And then the policy is subject to exceptions from coverage. So the difference between those two is exclusions from coverage are, broad, generic exclusions that would apply to any policy issued on any property. And exceptions are specific items that we're calling out that we're saying, okay, for this particular property, there is not coverage under the policy for this pre-existing easement agreement. So by identifying it in the policy, we're saying the title is subject to this easement. We are ensuring that you are, taking title or creating a lien, if you're a lender, on property with title that's subject to this easement. So that is something that is transaction specific, and it comes up when our title examiners research the chain of title or the title records to that property. If we're dealing with property that's held in trust or restricted fee status, then we go to the LTRO and we get title information from them through the title status report, and we will include the title exceptions from the title status report onto our policy. So when we have a tribe that's conveying or leasing or encumbering their interest in their fee land that they own that's unrestricted, and they don't have congressional approval for that, somebody may say, pointing to the Non-Intercourse Act, well, this act has never been repealed, there's no Supreme Court case on point, and we believe that this act applies to all lands held by the tribe, including lands they hold in unrestricted fee. And you may recall from Michael's earlier slide that conveyances, leases, encumbrances, anything that is completed in violation of the Non-Intercourse Act is not valid. So let's say that we insure, the sale of property from a tribe to another entity. If the Non-Intercourse Act applies to that property and somebody successfully argues that, then the deed would be invalid, and it would be like the conveyance never even happened. Same thing with, a tribe being a borrower under a loan. The tribe's going to get a loan from a lender. They convey their interest to the lender for the purpose of encumbering it with a mortgage. And, somebody argues that that conveyance is a violation of the Non-Intercourse Act, then the mortgage is deemed invalid. That's a problem for an insurance company whose sole purpose of issuing that loan policy is to ensure the validity of the mortgage, or when issuing an owner's policy, to ensure the validity of that conveyance. So since there is confusion and a lack of clarity from the Supreme Court, the title insurance industry will often include an exception to coverage on their policy for the Non-Intercourse Act. And this is just a sample of language. You may see it worded other ways. And basically, the exception to coverage is for any applicability or failure to comply with the Non-Intercourse Act as set forth in 177. So we're saying if somebody argues that the Non-Intercourse Act is applicable to this land, or they argue that the conveyance is invalid because of the failure to comply with the terms of the Non-Intercourse Act, then we're excluding that from the coverage under our policy. So that creates a real challenge and can be, frankly, a deal killer sometimes, which is really frustrating. What we normally see when we have an exception on our policies is, we have a preliminary report that we issue before the transaction closes and the final policy is issued. If somebody that's going to be an insured, like a purchaser or a lender, sees an exception that they don't like on their policy, they can say, hey, we're not closing this until that exception is removed. Like, for example, you already have a mortgage on the property. That mortgage has to be paid off because we don't want it encumbering the title when we, take title to the property. So if it's a lien or a mortgage, then we can say, okay, pay off the lien and it'll get released from the title, and then that exception won't appear on your final policy. If they say, we don't like this easement that your next door neighbor has to cross your property, we can say, okay, go negotiate a termination of that easement with the neighbor, and then once they terminate it, we can take it off the final policy. There's not really a simple path for removal of that non-intercourse exception. Really, the only thing we can say is if you don't want it on there, if you can demonstrate to us that you have congressional approval, through a congressional act to convey, lease, and encumber your fee lands, then we will, take that exception out. That seems like a really high bar, right? Like, we don't like this exception, we'll go get a congressional act. And that's what, like Senator Merkley was saying, that's absurd. Why can't a tribe do whatever they want to do with their fee land without having to literally get an act of Congress? But, there are some that are adamantly, saying to us, yes, the Non-Intercourse Act applies to all lands owned by the tribe, including fee land. So we have this conundrum. So let's see. I already talked about this. the requirement would be the Congressional Act, and that's what a lot of those tribes, all those tribes that Michael listed on his slide, have gone and done that. They've said, we don't want to mess around with this anymore. We don't want to have to deal with, purchasers or lessees or lenders who don't like this exception on their policy. And so we're just going to go get the Congressional Act so we can do whatever we want with our fee lands and not have this issue come up. So I'm going to give a couple of examples of transactions. This is all based on stuff that's actually happened and we've dealt with that is really challenging. So let's say that a tribe wants to put a commercial improvement on this vacant land that they own in unrestricted fee. So it's the scenario I was kind of presenting earlier. The tribe applies for a construction loan and they want to build a hotel. The lender says, great, we'll give you that construction loan. We need to get a title run from the local title company so that we can see what the title looks like. They get the title report back and it's got an exception for any potential applicability or failure to comply with the Non-Intercourse Act. And the bank says, we don't understand that, we don't like it, take it off. Well, like we talked about, there's no easy path for just removing it. It's not like, oh, it's a $10,000 lien, pay off the $10,000 lien and it'll get released from the title. So, we have to come back and say, well, if you want that removed, we need evidence that the tribe has a congressional act authorizing them to convey, lease, or encumber their lands. And if there isn't one, then the lender either has to say, okay, fine, we'll take the policy with that exception, and we'll take the risk that the Non-Intercourse Act applies, or the tribe has to put the project on hold and go pursue a congressional act, which is what the Seminole tribe in Florida did. And that's why they are the most recent tribe to go get a congressional act. Here's a leasing example. Tribal property owned in unrestricted fee. The site can support leases for office space or retail establishment. The tribe is using some of this space, but they want to lease out the rest of it to generate revenue. So they enter into a lease with a tenant. The tenant's attorney says, we want an insurance policy ensuring our lessee's interest in the land, so they order title work. Here comes the title report with the Non-Intercourse Act exception. Same thing as like when we're dealing with the lender. The counsel for the tenant says, we don't like the exception, we want you to take that off the policy. Same thing. Okay, does the tribe have a congressional act authorizing the encumbrance of the title with the lease? And if they don't, they either have to stop leasing to tenants, go get the congressional act, or they have to agree to take the policy with the exception on it. Last example I have here, just for a residential example. So let's say that your tribe has a program developing residential housing opportunities for tribal members. And you create a tribally owned entity to facilitate that program. So in that program, the tribal entity is the actual purchaser of the property and leases it to the tribal member individually under this rent-to-own program. Since the tribal entity is the fee owner, they are also the borrower under the mortgage. So both the lease, which is a conveyance, and the deed of trust, or mortgage, which is a conveyance, would be subject to the Non-Intercourse Act, resulting in exceptions on both those policies. We've already talked about how that plays out. Oftentimes, a transaction gets canceled because that lender or that purchaser or lessee is not willing to take the exception for the Non-Intercourse Act. A lot of times when people enter into a lease or purchase and sale agreement or mortgage with the tribe, they have no knowledge of the Non-Intercourse Act and no education on it, and so it's a surprise to them when it pops up on the title commitment. And we get a lot of tribes that are frustrated because they want to have control over what they do with their fee property that is not held in trust or restricted status. And we in the title insurance industry are frustrated because we want to be able to insure those transactions and not have to deal with a Non-Intercourse Act issue. But, we are subject to our board, our shareholders, our, reinsurance providers, people and entities that are not okay with us just ignoring that potential risk. So we have to show the exception. So, what do we do about this? I mentioned earlier that Michael and I are active with the American Land Title Association Native American Lands Work Group. One of the things that, we do as a work group is identify, in addition to tracking case law and legislation and the Hearth Act and, a lot of other cool things you guys have heard about today, we track legislation, and very occasionally we may decide that we want to support legislation to, assist us with being able to insure transactions in a way that will also assist tribal communities. So we have been talking for a long time now, probably a couple of years, frankly, about a legislative fix that clarifies whether or not the Non-Intercourse Act is applicable to fee lands. But as we started talking about that more, we realized that's not going to be a great solution because we have people, and tribes that are divided. Some want that applicability to remain, some don't want the applicability. So we came up with kind of a creative solution in the form of draft legislation, and we're wanting to show it to you guys today because you guys are the most important stakeholders in this whole process. And so what we're doing right now is we are seeking feedback from stakeholders before our work group even takes this to our board at Alta, and ask them to help us push it along, because we want to make sure that the legislation is something that stakeholders support. Otherwise, what's the point in trying to pursue it? So we're going to show you this draft real quick. I know we don't have a lot of time yet, but really, we're feeling like if a tribe wants to do something with their fee land and they want us to insure that transaction, the feedback we're getting is it literally shouldn't take an act of Congress for us to be able to do this and do what we want with our fee land. I'm going to actually pass it back to Michael while I pull up our draft legislation so he can talk about some of the other provisions.
One of the things that I think would make a lot of sense is to simply follow the path that a lot of prior legislation has taken. Congress has enacted a number of tribal-specific statutes to enable the alienation, encumbrance, and conveyance of lands. And so there's a well-trod path to follow. But of course, not all tribes, in the conversations we've been having, and as we've talked about, have consistent views on the desirability of doing this. And so one of the things that makes sense, as we've talked about this over time, is to say that this should be totally voluntary. If a tribe wants to clarify the applicability of Section 177, or that it doesn't apply to their fee lands, they should be able to opt in and simply make that not require going all the way up to Congress to do so, but make it something that can be determined at the tribal level. And so I think an opt-in or opt-out, a consent mechanism, would be one way to achieve this.
On a per transaction.
And of course, that could be done on a per transaction basis. The one specific transaction, we want to preserve or not affect the effect of it as to other transactions or to other lands, for example, or to specific interests in lands. We only want this to apply to leases that we give on lands and not to fee conveyances, for example. So these are the sort of the basic principles. And of course, tribes should be able to revoke the decision to opt in. And one of the issues with going to Congress and getting an act of Congress is, of course, that's it. It applies once the Congress passes the law. Tribes can't change their minds later. They'd have to go get another act of Congress to undo that decision. And so having the ability to simply opt in and opt out at a tribe's discretion seems to make a lot of sense. And of course, another core principle might be that opting in should only take effect, or the waiver of Section 177 should only take effect once there are actually third-party interests at stake. In other words, to enable voluntary conveyances of land, but not to simply waive the applicability of restraints on alienation and thereby subject lands possibly to involuntary conveyances. Involuntary conveyances would be things like adverse possession or tax liens, for example. So those are the general principles that have guided our discussions to date, and so that's what Megan's going to share with you now, is this draft.
Yeah, you can talk through it if you want, or we can together. Okay, so we took this name, Tribal Lands Economic Development Act. Did we borrow that from the Oregon tribes?
There's existing legislation that's similarly worded.
Yeah, there were 7 tribes in Oregon that banded together to pursue that congressional act for their benefit, so that they could, not have to keep addressing this issue of the Non-Intercourse Act coming up when they were, mortgaging or leasing or conveying their fee lands. And that is very similar to their name, so we borrowed that for our title here. Okay, so I'm going to just sort of scroll up the definitions. You can go ahead and go through that part, Michael. Here.
So there are really only 2 operative definitions here. One is, what is an Indian tribe? And so the obvious answer should be that an Indian tribe under this act is whatever an Indian tribe is under the Non-Intercourse Act, that is Section 177. It's probably also helpful to clarify, perhaps, that it specifically includes federally recognized tribes through a reference to the Federally Recognized Tribal List Act, or using other existing appropriate definitions in existing federal law. And of course, the only other operative definition is transfer. What does a transfer mean? That would mean any transfer of any type of interest from a tribe to a third party. That could include a mortgage, include an encumbrance, leases, sales, etc. Any encumbrance easements, for example, would satisfy that definition. And that's it. And again, borrowing very heavily and copying verbatim existing congressional acts, there's only one operative provision, which says that notwithstanding any other provision of law, Indian tribes may transfer all their land or any part or any interest in their land that they desire. This, of course, is subject to exceptions in subsection B. And the exceptions would be that it would not apply unless the tribe has consented to such transfer. Tribal consent, the ability to opt in and then opt out, of course, prior to actual voluntary conveyances, this core exception here. And so in order to opt in, a tribe must do 2 things. One is to consent to the conveyance or the transfer, and also express that consent through the actual instrument through which they transfer property. So that would be the deed itself, or the mortgage itself would show evidence of that intent to transfer the land. And of course, it would not include any tribal trust lands for which the title is held by the United States in fee for trust for the tribes. And again, that's just following the existing congressional statutes that have addressed this. Here's the real operative provision, which is, when does that consent, when does that opt-in become effective? And that is, it only becomes effective when the tribe engages in a voluntary conveyance. So only when the land is, or interest in land is actually conveyed to a third party, is the opt-in effective. In other words, before there are third-party rights at stake, third-party interests, that consent is revocable. In other words, tribes should be able to opt out just as freely as they opt in. And of course, once a tribe has opted in, the land title record should be evidence of that decision to opt in. Although tribes would, of course, have to convey the land with actual authority, the tribe would have to have authorized the conveyance. And simply to prevent any ambiguities or misconstruing the law, there are a number of rules of construction appended to it, such as that nothing in the operation of the act should authorize any conveyance of land for which is held in trust by the United States for the tribe, or affect the operation of any law that governs any tribal trust lands. It should, of course, not affect or diminish in any way tribal sovereign immunity as a defense. Also because, as we saw, the Non-Intercourse Act does apply to non-federally, or can apply to non-federally recognized tribes. It might be important to simply reiterate that this act does not by itself establish a government-to-government relationship, doesn't create federal recognition, doesn't take federal recognition away. It simply leaves that unaffected. And it, of course, would only apply to voluntary conveyances after the enactment of the act. It would never apply retroactively to anything that's happened previously.
So really our main goal here is to bring some clarity to the process, to make it less painful for, tribes that are wanting to convey, lease, or encumber their own lands that they hold an unrestricted fee, and to give, tribes an option so that it's not all or nothing. And, there may be lands that a tribe, doesn't want to remove from the protection of the Non-Intercourse Act, but maybe a different piece of property that they do. And so that's another thing that's nice about the opt-in, opt-out on a per transaction basis. This is only a draft. I have shared this with the Indian Land Tenure Foundation and a few other stakeholders, as have other members of the work group. But the part that we're at right now is socializing it to see what people that are impacted think. I've shared it with Sarah and Jeff from Schwabe, and they gave some good feedback. This is by no means a final draft, but we would like to hear what people think. And you don't have to tell us that today on the microphone in front of everyone if you don't want to. But if you would like to see, this is only 2 pages, so it's very short. If you would like a copy of it, or you would like to email us your feedback, we would like to hear it. And we just want to avoid, creating more problems or pitfalls for the true stakeholders that are impacted, because that's the opposite of what we're trying to do. We're trying to help and do it in a way that makes it a lot less painful for everyone. So that's kind of why we wanted to go through the history of the act, because it is so old, but it's still on the books, and it's very confusing. If anybody felt really confused after the first hour, we get it. That's how we feel too. So does anyone have any questions or comments?
My name is Lois Risling. My feelings about this was it's very distressing. And title companies have been the bane of my existence for about the last 5 years. We're from Northern California. We can't even get a title company to issue any kind of title reports. Our trustee, the Bureau, they turn somersaults, jump up and down, and do everything to try to make title companies respond to the tribe. They have more energy, they're younger than I am. But what distressed me about the presentation is the Non-Intercourse Acts were passed so that even in pre-colonial times up through the last one, to make sure that the federal government, it establishes that the federal government has responsibility to Indian tribes. That later gets codified into the Constitution. And it says, you have this responsibility. And you're right. They said, keep the white people out of Indian country and for what they're doing. Tribes have a legislative act if they're on reservation or in Indian country, and they have allotments that were given to them in public domain properties. That's Indian territory. Under the Dawes Act, we were certified, the Dawes Act said, we're going to take that property and we're going to put it into fee. You can get it into fee. And that's a legislative act. It devastated Indian people and Indian tribes. So when you're going to put property that we had to fight to get back, that's within the exterior boundaries of the tribe, of the reservation, and you're putting it back, it went out because of a legislative act. It's under a legislative act on how to get it through the fee process. That's a legislative act. Now for the title company, to me it reminds me of the old guys who are going around selling snake oil. The title company's job, and if you want to do something, your legislation should say a title report isn't necessary to put land for tribes into trust. We should be able to get our land into trust as easy as they got it out of trust. All you had to do was marry a white guy. I didn't. I married a tribal member, so my land has to go through this gymnastic system. But all you had to do under Dawes Act, if you were an Indian woman, is marry a white guy. And they would then give the land to him, because in that period, women couldn't own property. And that land went out of trust. Didn't take a title report. I've been in this business long enough. When I first started, title reports weren't required. And now we can't get the underwriters to underwrite our title reports. So that's what you should be saying, not to require these title reports to get land into trust, especially if it's on reservations. Now, I don't understand how the transfer of land from fee to trust with our trustee is like a purchase of land, or like you're selling it to some outside entity, because you're not. That's our trustee. We're part of that. So I think this whole thing, when you say, I'm trying for clarity to the process, you're adding to the confusion, and you're making it seem exactly like it's always been, that the native people, the tribal people, were the one who are going to lose on this. The title company's responsibility should be to help us not have to do title reports. So that's what your legislation should say. And if you were serious about it, you would have had hard copies that the tribal people here could have looked at, we could have talked about, and given you information, because there's a whole nother day. This approach is not good. It leaves me with a bad taste in my mouth, and I think that the interpretation of the Nonintercourse Acts is a narrow one that's designed to support your position, not our position. Thank you.
Thank you for your comments. One thing that I do want to speak to in response is the transfer of fee land into trust. There's a regulatory process for that, so that would not be impacted by this draft legislation that we're talking about here. And in May of 2016, the regulations were changed so that a title insurance policy is no longer required for a fee to trust transaction. And the regs now say that there needs to be some evidence of title, like a deed or a active, title report running the chain of title all the way up to current, but no title insurance policy is required to transfer property into trust.
I'm Lance Foster. I'm the Vice Chair of the Iowa Tribe of Kansas and Nebraska. And one task that my chairman asked me to look into, and that's why I'm attending here, our reservation, the state of Iowa was named after us. We had that whole state at one time and got winnowed down, collapsed several times, and part of the Kansas-Nebraska Act collapses further. to the point where there were only about 300 of us left, and then 150. And then allotment kicked in, and we lost 98% of our land. Our own little tiny reservation was all alienated. And so under the IRA, government with the Collier and those guys, they had a thing called the Iowa Project in 1936. They bought a few of the allotments back as a place to actually have a tribal office and stuff, because even the tribal members couldn't compete with the non-Indians on the reservation to farm our own land, because they'd all been alienated through mortgages and all that stuff. So, you know, the Burke Act and everything, it did what it wanted to do. And we know, I mean, we don't blame all people for anything, whatever, but the mainstream society is always about that old saying, they only kept one promise, to take our land, and they took it. So we know there's individuals, even in my tribe, you know, they buy a house, and then they want to sell a house, and the price is higher for a non-tribal member to live on our reservation. So we see this reverse action happening more and more with tribal housing. Non-tribal people want to buy all this fee stuff, and so we're losing, again, bit by bit, not just in terms of numbers and property, but non-Indians who get mad at the tribe for trying to control water quality and doing the things that we need to try to preserve a little tiny chunk, not wanting chicken ranches to flow their waste down the streams and all that. So we are befuddled and deluded a lot of times because we're so assimilated, you know, that we got to be like Americans and have that. I want to sell who I want to and a higher price and all that stuff. So most tribes have that tension between the people who already saw it and know the history about all your land is gone, and whatever you got back was on the bodies of our elders and their efforts. And then we got people who can subscribe to the world we live in now and trying to make retirement and try to sell their property and make the best of their, because they're thinking not as a tribe, they're thinking as individuals. And that's just, I'm not blaming either side, that's just two different totally ways of looking at the world. Mm-hmm. The land as property or land as part of who we are. So I see what you're trying to do. I don't blame you, because I think there are people in my tribe who want this. You know, other tribes, people in my tribe don't want this. So I see what you're trying to do. I think you're trying to do an impossible thing to satisfy everything like most law is. But I will take that to the folks there, but they need to understand they're just going back to what allotment did to us already and alienating, so we won't even be able to live on our own land, and everybody's hunting all our deer and doing all this stuff. So, you know, people, you know, it's up to you guys. If you want to be around for another 1,000 years, or if you want to fritter away into little tiny fragments all over the place and disappear, that's what it's all about. Taking our land in one little form or another and brainwashing us to think we got to be part of that.
Thank you very much. We'd want that feedback. I mean, if the overwhelming feedback is we do not want this, we will not proceed. That's why we're, you know, socializing it to try to get this feedback. So I appreciate anybody standing up and giving any feedback.
You know, our reservation is, I'm sorry, my name is Nathan Small. I'm the chairman of Fort Hall Business Council in southeastern Idaho on the Fort Hall Reservation. We have a little over 540,000 acres on our reservation. Several thousand of those acres were sold by allottees during that time. The tribes back then said that to its tribal members, if you want to sell your land to non-Indians and take it out of trust, then you will also lose your membership in this tribe. Because at that time, we didn't want to lose any more of our land to the non-Indians. So that kind of stopped the selling of land by individuals. So as a result, we were able to survive all of that stuff with the reservation that we have now. To 97% of that land is now under tribal control. the non-Indians that purchased land within the reservation, we asked them that if you're ever going to sell your land, sell it to us. We were able to work it out with all of the realty people in town, and we passed a resolution to indicate that we have first right of refusal. We were able to get that. So we were able to purchase land within the boundaries of the reservation. And a lot of time, and this fee land, a lot of this land had a home and structures on it, but it also had a farming place, farmland to it. So when we purchased this property, the tribe kept the land, the farming land, but the house and the structures on there were now available for tribal members to purchase. So if a tribal member was able to purchase this land, then they were given that opportunity. Some had to mortgage it. But the whole idea was that what we told them is that once you get all of your payments and everything off from it, then you can put it into trust if you want. Some of this farmland and that land that we purchased was not put into trust yet, but we did start leasing it. Is that a violation here? This is within the boundaries of the reservation. We've also purchased a lot of land outside the boundaries of the reservation, and we purchased these places. Usually it's in our salmon hunting grounds, our salmon hunting areas, because we do a lot of restoration, we do a lot of habitat enhancement, and we do everything we can to bring the salmon back. So we purchase these land that are near these rivers and tributaries. Some of those have structures on it, and we utilize that for our fisheries department. Our Fish and Wildlife department utilizes those. But in some cases, they also have a little chunk of land that we purchased that is also used for farming. And we lease that out to non-Indian leasers to farm that land. Is that a violation? Are we looking at something?
Are you talking about that land that you're leasing? Is it held in trust or fee?
We haven't put any land that we purchased
Fee? Okay.
in trust yet
Okay.
because of the goofy process that we have to go through.
If it's fee land,
Huh?
if it's fee land and you're leasing it,
It's fee land.
yeah, then arguably, the Non-Intercourse Act would apply.
Really?
Arguably.
Arguably.
Okay.
It's that lack
But
of
we've
clarity.
never been admonished for that. We've never been told you guys are doing something wrong here. And as far as we're concerned, we're using all of the sovereign ability of the tribe to do these things on its own without having to fear something like this. And we haven't met any of that just yet. So, I mean,
Right.
it's a hard situation when you think you can do things, either as a tribe or maybe as an individual, to get railroaded like this. I thought we lived in America, the United States, where all of these opportunities are available to everybody except for Indian tribes. What's wrong with this picture? So, again, like I said, I didn't see, it kind of came in late. But that legislation, is that what you're proposing to send? You indicated there was...
Yeah, right now, that's a draft that we are socializing it to stakeholders, so like tribes and
Okay.
entities that work with tribes to get their feedback, and that's part of what we're trying to do.
Okay.
It's still a draft.
I agree with the lady there. You should have at least had some hard copies to give out so that we can take them back. And either support it or not support it, depending on what the tribe wants to do with it. So, but I think, I don't know if this is going nationwide, or is it just for a few tribes here? You mentioned 7 tribes were on board.
So there are several tribes that have already pursued their own act for just their tribe. And then in Oregon, there were 7 tribes that pursued an act together to benefit all 7 of them. And so what we're proposing is, instead of, every single tribe having to go get a congressional
Okay.
act,
Yeah,
doing one,
I
national.
understand that part to make it better for everybody else. But did those 7 tribes in Oregon prevail?
Yes,
They did?
yes.
Really?
So that's an example of tribes that are saying, we're frustrated. We want to be able to sell our fee lands. We want to be able to,
Yeah.
lease and encumber. So we're getting kind of, both,
Okay.
both sides.
Well, I think, as I indicated, we seem to be doing things on our own and not being admonished for it or doing those kinds of things. So I would ask that you guys at least provide those this proposed legislation so that all tribes, not just the tribes that you may represent, but all tribes that want to get involved in this, be able to do that. I had a lot more stuff to say, but for now, that's what I'd like to bring up. And again, please give that proposed legislation so that all tribes can have the ability to look at that.
We'll make sure that it's available along with our presentation
All right,
to
thank
everybody
you.
that's participating.
All right.
Was the language proposed by the 7 tribes in Oregon the same as this, or how was it different?
It's essentially the same language with one exception, which is that instead of it being and it's not just the 7 tribes, there's a whole list of tribes that have it's basically the exact same language Congress keeps enacting. Here's the list of all the statutory references. It's the earlier, like the 1960 Navajo Act was written quite differently, but all the last 20 years, it's essentially the exact same language Congress keeps enacting over and over again for specific tribes. And so this follows that model as a framework. The one difference is that it provides an opt-in, opt-out mechanism without having to get a specific act. In other words, tribes can make it apply if they choose to have it apply without having to go get a separate act of Congress each time.
Or if they don't want it to apply, then
Then it doesn't apply at
they
all.
can entirely opt out.
Yeah.
Hello again. So in my course, in my profession, working for the Navajo tribe, predominantly working for large industry energy projects. The tribe proposes these energy projects, whether it's wind turbines, whether it's other forms of energy. It comes down to the Navajo Nation stating, actually the insurance companies request in a form waiver of sovereignty. That's what kills these projects. And I understand from the insurance coverage part that comes to us all the time for large projects. So the tribe, my tribe, I know these come to us. We submit it to the respective program. They look at it, waiver of sovereignty, they say no. Kills the project. people wonder what happened, how did this not get approved? It's for the benefit of our green projects, it's for the benefit of housing developments, it's for, that's the underlying deterrent. No matter how many people search and seek out these insurance companies to back a project, that's usually, I mean, I think that's what everybody is missing, is when the tribe decides that there's a statement in here in the fee land economic development plan, there's always that caveat that says, if you pursue this, then yeah, you take that risk or no. So yeah, that's what I think people have a difficult time understanding that component of it. That's my experience anyway for the last 25 years working as an archaeologist doing these projects. So I just wanted to make that known.
So you feel like the sovereign immunity waiver is the real deal killer, more so than Non-Intercourse Act issues? Thank you. All right.
Any
well,
other questions, comments? All right.
We'd
Well,
like to
thank you to the
all of you very
presenters.
much.
Thank you.